framework of the Initiative for Children in Migration, which is an informal collaboration of over 100 NGOs across Europe. And the focal points currently are Missing Children Europe, PICAM, and Child Circle. And in the past year, we received the support of EPIM and H&M Foundation, for which we're grateful. So this is the third in the recent series of webinars. The first one was a general one on the Asylum and Migration Pact of the EU as a whole. And then later in December, we had a webinar on child-centered relocation. And now we're going to look at what measures should be in place to safeguard migrant children at the EU external borders. After this webinar, Child Circle will share a paper on the issue, which is intended to provide recommendations and food for thought to all of the stakeholders in the discussions. So just to start with a very quick word of introduction on Child Circle, we're a centre of expertise on child rights and child protection in EU measures based in Brussels. And my name is Rebecca O'Donnell. I'm an Irish lawyer and co-founder of Child Circle. I'm delighted to be joined today by two associate members of Child Circle in London and in Switzerland, respectively, namely Nadine Finch and Josie Canix. Nadine was previously a barrister, human rights barrister, who specialised in children's rights, migration, and child trafficking, as well as international family law. She's been involved in important research in the field and was also previously an immigration judge. And Josie is a human rights advocate with a specialisation in children's rights. She's been working at international and European level for over 20 years and previously with a wide range of organisations. So just to say, in the field of migration, Child Circle is partners with Kind Europe, an initiative focusing on strengthening legal assistance for unaccompanied children, also at the border. So I mentioned that because we'll be publishing a report later in January, which should be of interest to you all. And we're also partners in the DCI-led European Child Rights Help Desk, which focuses on bringing child rights into the heart of decision-making on children and migration. And there was another paper published in December, which might be of interest. So turning to the purpose of this agenda, where we hope to identify issues, present some recommendations, but really leave some time for discussion and hearing your experience. This is our ambitious agenda. We'll just talk for a moment on the CEAS reform, our starting point, and then we'll look at what is happening at the border and the proposed procedures in a nutshell. Because you know the Commission has put a proposal on the table, so we'll just look at key elements of that. We've three key recommendations for change, and we'll look at those in overview and then look at each of them in turn. And we hope to we hope to leave space for us to share experience and explore issues together. We would ask you actively to use the chat to that end, and we look forward to hearing from you. So again, just to start very briefly with the overall context from the CEAS. The pact, as you all know, let's start first with the poll. We wanted to hear a bit from you first to understand maybe what your engagement with screening and procedures are. So you can see some maybe involved in service provision, others in human rights monitoring, policy development, guardianship, legal assistance. Great. So, and by the way, we were delighted to see such interest in the webinar today from so many different areas in Europe. It's great to be able to gather in the experience. So that's terrifically interesting, a lot involved in monitoring, and we will be looking at monitoring. That's one of our key recommendations. And policy development and advocacy is, of course, at the heart of this. Guardianship and legal assistance are very much a focus of our recommendations as well. So we will maybe, thank you very much for answering, and maybe we'll just go back then to a quick word on the CEAS reform. You will know that The pact was published by the Commission in September, and it included a wide range of new proposals, and that included a new pre-entry screening procedure, pre-entry into the EU, in other words, at the EU external borders, as well as new amendments to the asylum procedures regulation, which would introduce a new procedure for international protection at the borders in certain instances. In December, many of you joined general joint recommendations on the pact, key messages for children, which the Initiative for Children and Migration had coordinated. And that was shared with the Justice and Home Affairs Council. Now, the German presidency of last year, or of the last 6 months of last year, had hoped to end the year with political agreement on the pact, but instead they ended it with their own progress report, because we're still away from political agreement. And the proposed border procedures, as well as the solidarity mechanism, are still areas which divide opinion. Now, looking ahead very briefly, obviously the Portuguese presidency in the first half of this year, followed by the Slovenian presidency, those presidencies will coordinate discussions between the member states in council. And the European Parliament has appointed their rapporteurs and will start examining the proposals. And of course, the Commission will be actively engaged in working with those two institutes. I'm going to turn to Josie for the focus on our borders and to explain the scope of our discussion today.
Great. So if I can ask Rebecca, if you kindly could continue with the PowerPoint, and I'll just take a few moments to say where we'd like to start is with a quick snapshot to really explain in a nutshell what should be happening at the border under the proposals contained in the pack. So, as you may already be familiar with, the pact introduces a new mandatory border procedure for all those arriving at an EU border or those who are encountered on the territory having previously made an irregular entry. So for those who are irregular migrants or asylum seekers, they would now be dealt with in these new procedures. The focus of our webinar today is mainly going to be on the proposed pre-entry screening. So therefore, we won't be discussing in depth what happens in the exceptional scenarios. So for example, that's when there's a risk of pressure on a member state's migration management system, or situations of disembarkation following search and rescue operations, and other situations of crisis. So for most of the discussion, I think we'll set that aside, and that's perhaps the focus of a future webinar. But today, when we look at the pre-entry screening, the PAC's proposal is very clear on a few of the elements they envision that we'll be looking at in more detail. Pre-entry screening should entail, in that context, the identity check, preliminary health and vulnerability check, which would lead hopefully to referrals in some cases, as well as security checked, which is verifying someone's if they're a risk, and that might also be checking against the Schengen information system, and the registration of biometric data, so fingerprints and facial images, which would also be then captured in appropriate databases. As far as the range of the screening, the time given is up to 5 days, and for the purposes of screening, it would be implying then also a potential detention or deprivation of liberty for those 5 days. And in exceptional circumstances, that could go up to 10 days. So we'll come back to discussing detention later. But looking at the other provisions we see at the border procedure itself. So when we look at the border asylum procedure and the border return procedure, this would not be applied to unaccompanied children. They would be exempt. And families with children under the age of 12 would also be exempt. So I think this also raises questions about the screening, identification, and referral that we'll come back to in the course of our discussion today. And the border procedures themselves, we also wanted to underline that there have been concerns raised about the nature of the procedures, that this is really, in some cases, expedited. It would have perhaps diminished procedural safeguards. And when we look at what's happening for the asylum procedure and the return procedure, we're seeing detention that could last up to 6 months, or in exceptional circumstances, crisis situation, I think much longer, possibly 10 months. So there's a big concern about the use of detention, but also about screening and identifying vulnerabilities, identifying children in this context, and referring them away from the border. Throughout the process, those who are being screened or in a border procedure, they're not deemed to have entered the European Union territory, which is also problematic. And a final point that we'll discuss at the very end of the webinar is the proposal that each member state shall establish independent monitoring mechanisms. So I guess that's to end on a more positive note. And I would hand back to Rebecca to go through our key recommendations.
And we're going to look at these each in turn. So this is just an overview slide. And I had meant to say at the start, you are in a presentation which has a lot of text on slides. Please, that's just a guide for you, also to show you that it'll be available to you after the webinar. It'll be uploaded onto the Child Protection Hub site. So forgive us all of the text. But so in a nutshell, we have 3 key recommendations on the border procedures. I mean, we recognize the effort and the goal of the Commission to put in place something, that will allow for fast and efficient procedures in asylum and migration within the Pact. But our starting point is that the proposed procedures at the border should not become effectively an expedited substitute for normal migration management procedures within the EU. We in fact feel that the Pact should have focused on enhancing the normal procedure, and we're not alone in that thought. And one of the key elements in enhancing the procedures that persons, including children, encounter when they enter the EU is that there would be better case management. And the border, of course, provides a great moment to start that effective case management through putting in place a triage system. Now, to a certain extent, the Commission proposal aims to do that, but it, of course, goes beyond that in having broader ambitions for the border, that there would be quite a lot of expedited procedures. So first recommendation, and we'll go into it, as we said, in detail, is remodel these procedures so that they really focus on triage and exceptionally on expedited procedures at the border, and never applying those procedures to children, whether they be unaccompanied or within families, no matter what their age is. Our second procedure is that the screening procedures that will happen when a child arrives at the border, that those screening procedures are amended to ensure that they are child-centered and child-sensitive. And as Josie just mentioned, if you are going to have things happening at the border, obviously achieving transparency and accountability at the border, traditionally not a place where there is a lot of transparency or even accountability. So achieving that transparency and accountability through EU measures is very important. And that will be vital to avoid problems arising out of deliberate actions, or even just those omissions which may occur if the adequate resources, for example, are not in place. So we'll talk a little bit about how proposed monitoring mechanisms need to be designed to take account of the specific needs of children. So we're going to take a moment to look at remodeling procedures at the border, and I'm going to ask Nadine to say a word about our concerns.
Thank you, Rebecca. As you've noted, the proposed screening process is in essence an integral part of an expedited managed migration process. This is because, along with the procedures to identify the migrant, to undertake checks on things like public health and safety, there are a number of assessments, such as age assessments, national security assessments, which may prevent a migrant having access to the substantive international protection process. Furthermore, the premise underlying the process is also that many migrants coming to Europe have no entitlement to international protection, particularly if an individual comes from a country with less than 20% success rate by fellow migrants. And therefore they should be just dealt with rather summarily at the border. It's our view that this premise undermines the basic tenets of refugee protection and is likely to have a significantly adverse effect on children, particularly children who are accompanied and children who have wrongly been thought to be adults. To unpick that slightly, the Refugee Convention provides protection for individuals, not nationals. And a child may be entitled to protection, for example, as a child soldier, a girl who's been trafficked for sexual exploitation or a forced marriage, whether or not adults from the same state have not been granted asylum in many cases in the past. A child may also not be able to articulate a cogent claim for asylum without the assistance of a guardian or lawyer, as they may not understand complex concepts such as, are they a member of a particular social group? In addition, for a child to successfully appeal against an adverse decision within the screening process, they will undoubtedly need the assistance of a trained and experienced guardian and lawyer. Crucially, it's also the case that your child may be entitled to alternative forms of international or national protection due to being trafficked, because they've been tortured in the past or exploited, or purely on account of their very poor medical health. But without assistance, a child's unlikely to be aware of the availability of such protection or the evidence they need to show they need that protection. On a practical level, the proposed screening process may simply be unable to identify children at risk in time to protect them from abuse and exploitation. For example, screening still remains a primary responsibility of a small number of states of first arrival, and they may simply not have the resources or personnel to protect children on arrival. Alternatively, new restrictions at existing borders may lead to children resorting to more dangerous crossings controlled by smugglers who will then charge them money, which they will not be able to repay, and they will end up being exploited and abused. In addition, the proposals are that any child found within the state who has already made an illegal entry may be returned to the border. This will even be the case where the child's already receiving sufficient protection and support from a child protection service or their own family. This will further overload the system at the border. And as was said, the proposals stick by the legal fiction that a child will not have entered the European Union until they've been screened. This is legally unsustainable. And the European Court of Human Rights has over a number of years pointed out to member states that the fact that a child or adult is in a transit zone or is in a ship belonging to a state does not mean that the state doesn't have to treat them as if they have entered and are entitled to international protection. I'll pass you it back now to Rebecca.
Yes, thank you, Nadine. So in conclusion, and again, this is something that many others have said, many other NGOs, the PAC's rationale for the procedures proposed at the border does not appear to be wholly evidence-based. We don't know that it was preceded by a sufficient child rights impact assessment, which would have seen whether it's truly necessary, proportionate, or workable for children. And of course, we have concerns that there will be these breaches of human rights law, and at the same time, a failure of effective border management. So we truly think that if the procedures are remodeled and border zones were recognized as being within the member state's legal jurisdiction, that the border procedure would be a first step in triage. That would already require quite a few resources, but it could have a very beneficial effect for case management down the line. If the border procedure serves as a moment where persons can be identified, in particular that children are identified as children, accompanied or within families, or unaccompanied rather, and that preliminary screening is undertaken to identify the risks to health or security and public order, but in a provisional way in relation to children, and in particular that there is this preliminary screening and effective screening for vulnerability, so that children can be channeled into appropriate processes. So that, in a nutshell, is what we think should happen. And let's turn now to what we think that really would look like more closely. So just to say again, identify, do some preliminary screening, and then all children, including children within families, whatever their age, would be referred onwards away from the border. So that was our summary there. And now if we turn to child-centered and child-sensitive screening, I mean, a key point for us is that the screening procedures should be explicitly shaped and guided by the best interest principle. And that essentially requires that individual circumstances of all children be looked at, regardless of their claim and regardless of their circumstance. And we'd really like to recommend that EU guidance be issued on how this can be achieved. I think guidance of that kind would certainly support member states in understanding properly what they should do. The EU Pact, of course, in general, emphasizes that the Commission is intent on putting best interests at the heart of responses and prioritizing the rights of children. But we're concerned that that will remain an aspiration unless the screening procedure has both the right purpose and safeguards. And so, given that the border does not have can't handle very complex assessments of children's circumstances, we feel that it will rely on health and immediate protection needs being identified. It should also involve the EU recognizing that alongside migration management responsibilities, the procedures would serve as an element for the integrated child protection response that must also meet children when they arrive in the EU. Now that might sound jargonistic, but it breaks down actually into some very concrete actions. And kind of the basic overarching question is, how do you get the proper interaction between the migration management system and child protection at the border? There's plenty of experience really on, integration child protection with other processes, and really that kind of integration relies on a practical and comprehensive structural link. So you would have interagency coordination protocols between the migration actors and child protection actors. We feel the EU could very usefully produce guidance on how that interagency coordination would look, for example, a model protocol. EU measures should explicitly promote a multidisciplinary approach to screening procedures. Now, there is precedent for that in EU law. In the criminal justice proceedings, in the Child Procedural Safeguards Directive from the EU, member states are required to take individual assessments of children's needs with a multidisciplinary approach. So we'd encourage that to be explicit also in the screening procedure. That would basically ensure that an appropriate range of professionals are actually present in the screening procedure, and that will allow the procedure to be conducted in a way that ensures that the individual child's various needs are met. In essence, that would mean child protection officials would be at the border alongside border agents. Nadine's also mentioned that guardians should be there for unaccompanied children. And one of the things we feel is that EU measures should promote joint training between all of these actors. And of course, the Fundamental Rights Agency has issued some very interesting guidance and recommendations around what border guards need to do and what kind of training needs to be in place. Now, we should really be careful to acknowledge that a child-centered and child-sensitive approach is important in all cases. It's not just for unaccompanied children. It's for children traveling alone, but also with families. Children and families, as we know, are often invisible, it's often said. But at the border, one can quite easily envisage the case that a parent is not deemed to have a substantive asylum procedure due to their country of origin, and the child's circumstances aren't even properly considered. Whereas the child may have a child-specific ground for international protection. And also, obviously, one might encounter children apparently within a family. But of course, the child may not in reality be a member of the family because they're already being exploited or it's planned to exploit them in Europe. And that's something that happens regularly. Providing guardians and child protection officers and lawyers later on in the process would not be enough. So they need to be there at the screening procedure. And in particular, a child may give an account in the screening procedure if they don't understand it. And that account may frankly later on seem quite incredible. But it's really down to the child not understanding the procedure and maybe having been told to say something. They need independent guidance for that purpose. So I'm now going to hand over to Nadine to look at some of the key safeguards. We don't have time to do this comprehensively. Our paper will add more, but here are some of the key safeguards I think should be in place.
Thank you, Rebecca. I'm going to look first of all at provision of information and support. Now, there is no provision in the present proposals for the appointment of a guardian or lawyer for child who may be at risk on their arrival, or the provision of some of the other safeguards which are already in EU law in the reception conditions or asylum procedures directives. Those haven't been copied into the proposed screening procedures. The proposals go no further than referring to the fact that national child protection authorities may be involved. They don't explain on what basis this involvement may happen, or where, when, or how it will occur. Most of the time, the children in the screening process will be treated in the same manner as adults, despite the fact that they lack the legal capacity of adults and will not be able to give informed consent to many of the procedures they'll be asked to take part in. Now, there are particular issues we are concerned about. Without a guardian or a lawyer, children are very unlikely to be able to understand the particular information they need to provide whilst being screened. The screening that's being proposed is not just a simple tick box data collection procedure. It involves a number of complex issues, such as whether you are a risk to national security or to public order. There's also a new debriefing procedure, and debriefing procedures are most usually used with agents or with professionals when they've been on some kind of assignment. It's not a concept one normally applies to children. And it's likely that children will find it quite difficult to answer some of the debriefing questions. In addition, the child's age and existing additional vulnerabilities, such as not being literate, having a medical condition, may have a direct impact on their ability to provide accurate information and an understanding of whether they're entitled to any protection. In fact, they may not even have the understanding and language to actually articulate a claim for protection. And if they don't articulate a claim, that might be subsequently fatal to their application. As been said before, they may also be wrongfully age disputed, may be detained and referred and not referred into the appropriate child protection system. Quite worryingly, they may also give the wrongful impression that they may have been involved in terrorism or organised crime, when in fact they've been exploited, trafficked and abused. This may be particularly the case if a child's been involved as, by force as a child soldier, or within a criminal gang, such as a child trafficked to take part in cannabis cultivation in another country. Back to you, Jyoti.
Yeah, so we'll turn to the next slide to see a couple of our key recommendations that could address the concerns Nadine just highlighted. First of all, a really important point is for the screening proposal to be amended to include more specific obligations about information and independent support and assistance that should be provided to children throughout the screening process. And in particular, in that regard, the involvement of guardians for unaccompanied children and the front loading of legal assistance for all children, as Nadine was explaining, as they're engaging in debriefing or screening procedures which may impact subsequent decisions. So these are a few of the key points, and for each area we'll continue to highlight some of the recommendations, but again, the paper will have more. And later in the discussion, it would be interesting to hear from you if you have good practices already in your country in this regard.
We also have a number of additional concerns about age assessments and age disputes. We accept there'll be a minority of individuals who may pose as children on arrival, but against that one has to balance the significant damage done to children who are thought to be adults at a border. They become subject to expedited asylum and return processes and may eventually be wrongfully referred to their country of origin. In the meantime, they are detained with adults who may include potential traffickers and be at risk of exploitation and abuse by those adults. It's also the case that age assessment is a very difficult process in the best of circumstances. And when a child is detained at a border, that is certainly not the best of circumstances. GASO and many individual medical and child protection experts have recognised that assessment of a child's true chronological age is a significant challenge. Medical assessments can at best identify physical maturity as opposed to chronological age. It's now widely believed that a multi-agency assessment involving a number of different professions is the most likely to arrive at an accurate chronological age assessment. But that would simply not be possible in the time constraints at a border. It's also very unlikely that such a multidisciplinary panel could be brought together at a border. The EU has also recognised that the migrant flow into Europe involves a number of children who have been trafficked. And the law on children who have been trafficked is such that where a state has reason to believe that a person may be a child and trafficked child, and the age is at least uncertain, the authority must presume that the person is a child and receive them into a safe place with support and assistance until their age can be ascertained, which does suggest that this should be away from the border. Furthermore, there is a new proposal in these wider proposal, which is that the age of 12 is a watershed, not just the age of 18, where a child is accompanied. It's clear that border officials are unlikely to have had to apply an age assessment of whether a person is above or below the age of 12. There would not appear to be any guidance in such an assessment or evidence that such assessments can be undertaken with any accuracy, which again is a considerable concern to those looking at these procedures. Back to you, Jyoti.
With regards to age assessment, our recommendation is that during the screening procedure, that it should be confined to assessing whether there is reasonable doubt of the age of an individual, and if there is, that there should be a referral and the benefit of the doubt should be applied, and the individual should be treated as a presumed child, and then away from the border, gone subject to the subsequent more in-depth age assessment. So again, it's more the identification and indication of doubt at the border, but referral away from the border for age assessment procedure.
Okay, I mentioned before the debriefing process, which is a new concept. The background to this debriefing is that the amended proposal for a recast Asylum Procedure Directive is that any information that's collected during the screening process goes towards the overall assessment of credibility of a person. Procedure could be fatal to a child's asylum application. Now, the debriefing form, which is attached to the draft screening regulation, mainly contains standard biometric questions. But there's also a section at the end which relates to the child's journey and to the funding for their journey. Children are very unlikely to be able to give a full explanation of their journey for a number of different reasons. Firstly, their age and the fact they're likely to have a very limited experience of international travel. But probably more importantly, many children are told to lie about their journey. This is to protect the routes used by smugglers or the involvement of a parent or another adult. And the children may well continue to lie throughout the screening process. This will ultimately have a very adverse effect on their own credibility. In the alternative, I've seen some children who were asked questions on arrival, and when their answers were not believed, have then changed their stories and created answers they thought the adult interviewer may be pleased with. It's also the case that, quite aside from the credibility issues which may arise, that the child is not positively asked during debriefing about any other entitlements to protection they may need, which could be a national or another international type of protection. And they are not provided with an opportunity to make such a claim. Many children may not qualify protection under the Refugee Convention, but they may well be stateless. They may be entitled to protection under the Trafficking Convention, and they may simply be entitled to humanitarian protection on health grounds. Without a guardian, it's very unlikely that the child will provide the necessary evidence and information to show that they may be entitled to such protection. And therefore the debriefing process is very likely to be adverse to their best interests. Jyoti?
And turning to our recommendation with regards to the debriefing part of the procedure, we would ideally like to see that limited in scope and purpose, but also to the extent that information collected during debriefing is used to examine a person's claim for international protection. Therefore, we would feel in those cases it's even more important that the child is guaranteed independent support and assistance. And once again, that would include front-loading the legal assistance. So as Nadine explained, they have support in articulating their claim and their protection needs if it's feeding into that process.
Now we've mentioned detention as we go through. And despite the fact that the United Nations Convention on the Rights of the Child and the case law of the European Court of Human Rights indicates very strongly that children should not be detained for immigration reasons, and that if they are detained, it should be that for the shortest possible time if there's no alternative that's reasonable. The present proposals are likely to lead to both unaccompanied and accompanied children being detained for much longer than is said. It's also the case that UNHCR is quite clear that children and families should not be detained in closed settings, but the family should be provided with accessible, safe and appropriate care arrangements. Yet the experience in Greece and other countries of first arrival is that both accompanied and unaccompanied children are being detained on arrival because these countries simply do not have adequate personnel to process arrivals in a timely manner or non-custodial accommodation in which to house children and their families. It's also the case that the complexities of the proposed screening process, especially when a child's involved and there may be additional issues around the child's understandings, their health, their age, is likely to take much longer than the proposed 7 days or more. Even a proposed 5 to 10-day screening process for cases which are referred to substantive asylum process would necessitate in reality a very much increased amount of people and resources at the borders, which, as I said, may be way beyond the capacity of the state involved. It's also proposed that children accompanied by their parents who are over 12 are detained or may be detained for up to 6 months, depending on what happens to the claim of their parent. Yet, there's no evidence that children of this age, between the ages of 12 and 18, are physically, psychologically, or emotionally capable of withstanding long periods of detention without suffering various forms of harm. It is unclear why there is an artificial divide at the age of 12, why it's thought applicable to detain children over the age of 12 when you wouldn't detain children under the age of 12. In addition, these children may well be held with other families and other adults. And experience has showed that that will open them up to possibilities of abuse and exploitation by some of those adults. It's also possible that in order to avoid a child being detained with an adult, the adult may send the child on alone ahead as an unaccompanied child. And that child will be exposed to all the possible abuses of being trafficked and abused on their own. Therefore, there are many issues about detention which just have not been addressed in the present proposals. Jodie?
Yeah, so as Nadine said, immigration detention is never in the best interests of children, and we recommend that it's avoided even at this early screening stage, and that unaccompanied children are referred to alternative care arrangements, and that children and families also are not denied their liberty. So liberty being the default, and when there would be a need for detention, that then alternatives to detention should be considered, ideally in community-based arrangements for children and families. It also means that the screening procedure should ideally be, in principle, quite short, and within 24 hours that the main health checks should be undertaken. And in the exceptional circumstances when there may be a crisis situation or an influx, that those procedures are ongoing, that at the same time adequate reception is still provided. And again, I think we have some further questions and challenges in the proposal, but we have also some good practice models for alternative care and for placement in the community, as well as alternatives to detention when they're considered.
Thank you. And I think at this point, if I'm not mistaken, we have a poll, but I may be mistaken.
Yes, there's a poll.
There is a poll. So, Vesna, if you have it to hand, we'd love to hear from you. I think maybe even there was, yes, there may.
Hope that you can see it. It's on the screen.
Yes, yeah. So as we turn in to the border procedures, or the independent monitoring, we're very keen to hear what's in place. So whether you have an independent monitoring mechanism in place, and how.
And
hand over to Josie for the second, yeah.
And we partly thought to give this poll because while we welcome that the EU Pact has a new proposal for each member state establishing an independent monitoring mechanism, that's something we really welcome. But we also realize that there are different kinds of monitoring already going on for reception conditions, for return procedures, and also sometimes in a very, as you've noted here, tripartite way. So you often have previously, for example, in Central Europe, UNHCR and government and NGOs having a tripartite agreement, which in some cases has now gone on to other frameworks, also involving national ombudsmen. So I think it's really a great opportunity we have here to strengthen the monitoring of fundamental rights. And I think for some of us also to check what's happening in our own countries for monitoring different procedures. So I hope this last part of the presentations will be inspiring and thought-provoking for you. I think there we see the results of the poll. So turning to what the screening regulation proposal says in Article 7, if you're interested to take a look, it does call on member states to adopt provisions to investigate allegations of non-respect for fundamental rights and to establish independent monitoring mechanisms. So this is something we really welcome, as well as the provision that the member states shall put in place safeguards to guarantee independence of these mechanisms, and the role proposed for the Fundamental Rights Agency in issuing guidance to member states on both the setting up and functioning of the mechanisms in an independent way, as well as methodology and possible training schemes. So I think if we turn to the next slide, we have a overarching recommendation. I think Rebecca has the next slide. Whoops. And there, I think what we really see is that monitoring can contribute to enhancing transparency and accountability. And that has an important role, or is vital, not only to preventing human rights violations, but also to improving our responses to such violations. And as we go to the next slide, looking at how we design monitoring or strengthen monitoring, which actors are involved, we should take account of the specific needs and rights of children and safeguards that need to be in place for them when we look at the implementation of the Convention on the Rights of the Child and the Fundamental Rights Charter, also in this context of screening and border procedures. But looking a little more closely, the pact, as we said, it's proposing that member states should establish independent monitoring mechanisms. And we also wanted to underline in our recommendations and in our exchange that this is more than site visits or reporting, but that really monitoring is a process which is often embedded in a strategy. So we see that that process is also informing a dialogue which can lead to further interventions and actions. And that might help us identify the need for capacity building or better ways of working. So this is again, I guess, improving the system, preventing and responding to human rights violations. And in that regard, we also agree with the positioning of ECRE and others that monitoring needs to be expanded beyond the screening procedure. So all the procedures that are taking place within the pact that we see at the border, this can also be subject to monitoring by independent authorities together with national civil society, NGOs, but also perhaps coordinating with international monitors that may come. So I think we have a lot of models in place already, but in bringing forward this proposal, we'd like to see how to fill the gaps in the existing monitoring and strengthen cooperation. With regards to these monitoring activities, again, we'd like them to be looking at the policies and laws in place, and as well as how the procedures, safeguards, service and conditions are how they are those that which may affect children. In that regard, some of the measures that we're looking at, or procedures, conditions, some of them already have monitoring in place. For example, monitoring of detention conditions or reception conditions. But we'd also, as we said, like to look at the gaps and see how we can bring other monitoring models to look at procedures such as age assessment and identification to make sure that we have the right indicators to identify stateless children, to identify children who may be victims of trafficking, and look at the capacity of the actors involved in those identifications and referral systems. And then also looking again at procedures. So for example, some countries have quality assurance in place, looking at the handling of cases of children and families. And this is something that would be important to see given in guidance and training to other countries as well. So I think here we have a wide menu of procedures and safeguards and services and conditions that could be monitored. And in some cases we have tools and resources for that work. And in others, I think we need to perhaps develop and exchange more. Also, of course, a link with monitoring is making sure that complaints mechanisms are established, fully resourced, and in this case, we would again underline that they're child-friendly and accessible. So we know that there's an interest and willingness to do that. But for these new procedures, again, we might need to strengthen the capacity of actors to do that on the front line, and perhaps learn from the work of children's ombudsmen at the national level and others that have that capacity for consulting with children and handling their complaints. On a related note, as we also mentioned earlier, children in that respect should also have access to legal assistance providers who are competent to support them in those procedures in order for them to address violations of their rights or to bring complaints. And for unaccompanied children, that would also be improved by the support of an independent guardian to help them seek remedies. So the complaints mechanisms are a key component that links into the overall monitoring mechanisms. And we'd like to see them strengthened also at the front line in screening and borders. And we'll go to the next, I think. And here again, in order to have that happen, we'd like to see child protection actors involved, as we said, to monitor indicators related to children's rights and child protection, but also to consult with children or perhaps to take their complaints or be part of a referral mechanism. And that again means enhancing effective cooperation, as Rebecca mentioned earlier, in a more integrated child protection system also at the border. The monitoring framework ideally should clarify the mandates and roles of the different actors. We have also some good practice examples from member states in this regard, and some interesting examples of how the different national strategies link with international actors who also have a mandate to visit and to give recommendations to member states. In that case also, we highlighted here the Council of Europe, Greta monitoring body looking at the implementation of the Convention Against Trafficking, but also children's ombudsmen or human rights ombudsmen who also work often very closely with NGOs to fulfill monitoring role in the national setting. A second proposal that we welcomed was that the Fundamental Rights Agency should issue guidance and support the member states with monitoring methodology and appropriate training. This is, as I said at the beginning, with regards to guaranteeing the independence of the national monitoring mechanism. What we would also like to see there is that the guidance specifically address how children's rights will be monitored. In that process of developing the guidance, we would suggest and recommend that the Fundamental Rights Agency also consults with child rights and child protection experts, whether that's NGOs that are active in the field, who also have developed models, for example, for monitoring detention or taking complaints from children, but also the ombudsman for children. So there, I think, there's a lot of valuable experience that could help shape the guidance when we look at protection of children's rights in the context of screening and borders. And if we go to the next slide. Oops. I think there was another slide, but oops. One of the, yeah, there was, I think somewhere we missed a slide just to end, that the pact also proposes that there should be independent monitoring as an essential part of migration governance, and that this should be included in the national strategies. So under the pact, there's, I think, an EU strategy as well as national strategies. That's also, I think, the slide where I was mentioning that there should be a monitoring framework. So I think that's looking to, again, just strengthening cooperation and resources going into the monitoring mechanisms and making sure that the different strategies and mechanisms have a child-sensitive approach, and that we really underline that protection-sensitive screening and entry systems are strengthened and child-centered. So I'll end there, and I think hand back to Rebecca. We have about a half hour for clarifying any points and for discussion and exchange of hopefully also some good practices. Thank you.
Hi, thanks, Josie, and thanks, Nadine. And indeed, we have marched through a lot of territory and quite a lot of technical detail. So thank you very much for your patience. And now we're keen to hear from you all. I'm wondering, do we have one more poll though? Because am I right that we had a poll which was to ask people what they thought might best happen at the border? Am I right on that?
Yes, I will share it now.
Because I think in summarizing, obviously, as we said, we think the key issue is to remodel the border procedure and have what can happen usefully at the border happening effectively at the border. And then that it's monitored properly. So it'll be a virtuous circle of learning. I mean, we're conscious going into this territory that, of course, there are lots of different kinds of borders, land borders, sea, air. So, you know, what exactly happens and how it can happen, it'll be very interesting to share experience. So I think there we have some very interesting responses, and health checks are clearly recognized. The security checks, obviously, and age assessment. So thank you for that. Vulnerability screening and identification of victims of trafficking come out very high, the highest. None of the above and all of the above. I don't know whether the person saying none of the above doesn't want to see anything in particular happening at the border, but only away from the border. And then all of the above. I think, as you know, we probably agree with all of the above. But thank you very much for sharing your thoughts on that. We hoped to hear from you now. I don't know whether people have had a chance to add anything to the comments. But a big question to you is, what do you view as the biggest challenge for states at the border or for actors helping children at the border? Or what is your greatest concern in relation to the proposal? It's very importantly, because as we said, we're developing a paper on this, have we left something out? I mean, again, we didn't get a chance to talk about all the different things that should happen at the border, or go into detail, for example, about how vulnerability screening could take place. But we'd be keen to hear more from you. Is there anybody who has experience to share? And maybe we can either look to the floor and give you the floor, if that's possible. Then I'm not sure. But if anyone has something they'd like to share with the group, maybe they could indicate it. Otherwise, I will bounce back to Josie and Nadine, maybe to add a little more on any of the points we've made.
Oops. I can answer one point briefly that I would also welcome during the discussion or afterwards to exchange more, because I think one of the questions was the biggest challenge, and I think for many actors the biggest challenge can be access to what's happening at the border, whether that's a physical border or institutions at the border, facilities that may be closed. And that's again why I think we welcome the independent monitoring. So if there will be national strategies, maybe that's a place to put a hook to clarify some cooperation between agencies, and whether this is, I think in some cases, very formalized through memorandum of understanding or standard operating procedures, but really seeing who has a role and a mandate at the border and how do they cooperate with each other and who has access. So I think going forward, advocating for child protection actors, whether that's guardian for unaccompanied children or other child protection actors who might be not supporting, but rather monitoring. This will be a key point. And I think in many countries and contexts that having access and being able to directly consult is a challenge. And related to that is also, of course, on a practical case, interpretation and translation. So if you have access, if you have the skills to communicate with a child, I think it's also a question if all of the services at the border are independent, professional, how they cooperate, and again, if there's gaps, like I think interpretation and translation would be another. But if anyone has examples you'd like to share about accessing at the front line or good models of cooperation, that would be something interesting to follow up and to showcase. And I think also to inform the guidance that Fundamental Rights Agency and national authorities will be working on, that we do have good practices, but yeah, number one challenge for me was access and I guess capacity and skills there at the border.
I stopped sharing the screen so that if anyone wants to share or come online or reveal themselves, that would be welcome. It's nice to feel sometimes that we're all in the same room, although we aren't yet. Nadine very much in lockdown in London. Sorry, I don't mean to laugh, but it's we're glad that you're with us all the same. The joys of virtual environments. Virtual is the new real. It may be interesting to some of you who may not have seen it, but before Christmas, Greece, Italy, Malta, and Spain shared some comments on the new pact, which I think became available on State Watch. And they did express the concern together that, I mean, they think whether or not to apply border procedures, as well as the categories of persons to whom these should apply, should remain a prerogative of member states that are best placed to decide if a procedure is feasible, given their specific circumstances. So, I mean, that is a statement that suggests perhaps that either mandatory procedures proposed by the EU should be very limited, and that member states should apply a lot of discretion in that regard. They also made the comment that setting up large closed centres at the external borders is not acceptable, because the management of asylum must fully respect human rights and the rights of asylum seekers. So just to share a little bit some of the reactions, I think we also had some echoes that some countries feel that the exceptions from the border procedures relating to families with children under 12 perhaps actually might have adverse effects, and that families with children under 12 should be part of the border procedure. But again, this is all part of the contested territory, or the territory that is being discussed between member states and the stakeholders. So see a comment from Grania Farrell. Thank you, Grania, from Project Play.
And there are two above Grania as well. Grania. So there was a question, I think, for Rebecca, more about the EU agenda from Mohima. And Arya, I will also reply to hers in a moment. But do you want to start at the bottom and go back?
Maybe, in fact, because mine is showing backwards.
Or I can read to you, yes. Maybe. The first one was, could you please tell us something about what is going to happen during 2021 regarding the pact? Mainly the work with the pact. Also the age limit of 12, do you see that it will be any change to also include children up to 18? So it's two questions about the negotiations going forward. And I think Rebecca mentioned a little bit about that at the beginning of the webinar. I don't know if you want to.
I mean, just obviously, just to say the procedures remain very much a priority for the presidency. I mean, the current Portuguese presidency, and Slovenia being the last in the trio from Germany, Portugal, and Slovenia, all of whom committed to really making this a priority. As I said at the outset, the Germans were unable to achieve the political agreement, but maybe that's not surprising, or it certainly isn't surprising, given the discussions that took centre stage on the budget during their presidency and the rule of law issues. So the Parliament also will gear up, as it were, on looking into the details of the proposals from the Commission. So in short, I mean, the discussions continue. There'll be others on the call who have a very clear insight into the very next steps. But just to say, I think people don't expect at all the initial, probably certainly optimistic timetable of the Commission, that a lot would be negotiated and agreed by the end of the first half of 2021, that simply will not happen. And as we said, you know, the opinion is very divided. And that has meant that some of the states are refusing to agree those parts of the overall package that are perhaps less contentious, but are saying, no, let's just negotiate everything together. So in other words, certain things do not move forward that maybe the Commission had hoped would move forward, regardless of the more contentious issues.
Very briefly to answer Arya, there was a question about sharing good practices with regards to case management and alternatives to detention. And I'll put a couple links here in the chat, but I would encourage you to check the UNHCR Ref World page for detention has options papers that include some national practices that are noteworthy examples, and the International Detention Coalition has some projects in Europe with partners piloting alternatives to detention, I think with support from the European Programme on Integration and Migration. But I will put the links there. I think looking at what UNHCR has produced with governments and partners, the International Detention Coalition, and also the Council of Europe, some parts of the Council of Europe have supported, they've had a campaign to end the immigration detention of children. The Parliamentary Assembly of the Council of Europe and the Committee dealing with Human Rights has a practical handbook. So I think when we look at monitoring and alternatives, those are some starting points, and hopefully in the coming weeks and months, we'll have some more exchange and more current examples. So I look forward to exchanging more on that. The next question, Rebecca, was the one you had mentioned, sorry that I interrupt, from Groine, who said that for them, it's a challenge for them as the border in northern France now switches to an external EU border, and the implications this may have on communities and what it means for return procedures, access to claiming asylum within the UK, etc. So I think that's a point definitely that both Rebecca and Nadine could react to, as Nadine's based in the UK, and yeah, everything is changing at the moment, and there are a lot of questions and challenges.
I think the situation in the UK is very complex in that although there's a lot of talk about the channel crossing to Dover, actually a lot of children are coming in through Portsmouth. They're not coming through Southampton because it's a container port, but they're coming through Portsmouth. They're also coming through a lot of smaller ports up the eastern seaboard, which raises lots of issues about, at the moment, there's capacity from local authorities to look after those children, but quite how skilled they are at spotting trafficking, or whether there are lawyers there to assist those children, is completely another question. There's also as yet very little discussion about the Irish border, which is, as Rebecca and I both know, is an extremely porous border, which is incredibly long. It's about 300 miles long because it goes all over the place. At the moment, it's known that children are trafficked across that border. But I suspect that smugglers and traffickers are going to try and use that border much more in the future, which will be challenging for both Ireland and also Northern Ireland. The other thing which is happening in the UK is that the government is already using ex-army bases to detain people who've made border crossings. And there's one proposed, but there's not much known about it, near Winchester. And it appears that a lot of age disputed persons will be housed there. And it is clear that age disputes are going up for people crossing them, making the channel crossing. So there's going to be a lot of issues for children who get into the UK. My personal view, and I've got no evidence for this, is as soon as the UK cottons on to what's happening in new pacts, they are going to try and adopt very similar methodology, because they've always wanted to offshore asylum applications. And once they realise that actually they could say, okay, people aren't actually, they could hold people at Dover or Portsmouth, but they may well try it. And that's something which I think may happen soon. And also, it's very difficult to monitor what's actually happening in the channel. We know that quite a few boats have sunk. What we don't really know is how many boats have been sent back, because they are very, very small. The craft that come across are very tiny. And so it would be quite easy for a boat to be towed back to a small port. And it's certainly not only the smugglers are moving up the coast of Europe. So the boats aren't just coming through from Calais, they're coming through from higher up the coast. So I think it's something to really watch, because there could be all kinds of abuses. Do you want to add anything, Rebecca?
No, not at this time. I mean, I think a kind of a general point that came to my mind as you were talking of the UK issues is, I mean, we're very much looking at these new proposed border procedures, but they are procedures that will take time to be negotiated, and then it'll take time for them to come into force. But the fact that they're on the table may provide inspiration to member states under their own national laws in relation to border procedures. So it will be very important for actors around Europe just to keep each other informed of practice, good and bad, that is developing. Because as we said at the outset, we don't feel that there was a full child rights impact assessment of these procedures. When we unpack them, we have a lot of very specific questions. And it'll be interesting to see how those details are either already addressed in practice or will be, for example, particularly in the UK, who may feel more agile now and able to develop those kinds of border procedures. Maybe they'll detain people on the naval warships that they had patrolling the channel before Christmas, without being facetious.
And we have, I think, a couple more comments in the chat and questions. One from Thomas was regarding what's happening after the border procedure, and if we have recommendations with regards to the solidarity mechanism in general and relocation of children specifically. So it's a bit outside the scope of this webinar, but I will look, we've had a couple webinars recently on relocation, so I will try to put those links in the chat as well, and maybe hand to Rebecca if you had a brief comment, or also to highlight the other papers.
No, this is a nice question to get, because we can refer you directly to a recorded webinar where we heard it was a very, very interesting discussion with different organizations around Europe who've been working on relocation and how things are actually happening right now. There's also a paper that Child Circle and Missing Children Europe prepared on having a more child-centered relocation procedure. So we have specific both questions and recommendations on the relocation mechanism proposed in the new asylum and migration management procedure. And again, just Thomas, if you're familiar with, which you undoubtedly are, with the Dublin regulation, you know, some of our concerns are that there isn't, in the same way as the Dublin procedure lacks, you know, detailed provisions on how member states coordinate between each other on best interest procedure, or how the legal assistance and guardianship of children is assured in a continuous and stable way in transnational procedures. So there are some of the issues we looked at last time and where we have very specific recommendations. So that's helpful.
And I've just added 2 of the links to previous webinars on relocation. If you haven't seen them and are interested in that topic, some very also interesting practice shared.
Yeah,
so I think
maybe if I could just add, sorry, I mean, when we were looking at relocation, we really thought that, you know, you have a number of different steps that feed into relocation, and some preparation for children that is necessary before relocation. So again, the idea that a child might be lifted directly from the border and relocated to another member state isn't something that we would see as likely, save in exceptional circumstances. So again, children would be identified at the border, referred into child protection setting, and then the more complex procedures be applied there, that the best interest assessment for relocation alongside other things happens away from the border.
Okay, and I think we had just one final comment, which fits well with our timing. Philip was asking, what are your thoughts on the more overarching issues of the trajectory the pact embeds? For example, reinforcement of harsh, less rights-based approach. And he's also commenting on the putting the marker for age at 12, that this was an attempt to balance the proposal. So I think compromising to help some parts perhaps go forward to aid the transition, avoiding inclusion of all children. So I guess if there's other comments, I think we would agree with your analysis that's it's less than a rights-based approach if we're defining child as 12 and under, or that these I think putting the measures at the border, as we said, where it might be expedited or have fewer procedural safeguards, we're also really concerned that it's a less protective approach. I don't know if Rebecca or Nadine, if you wanted to react to that in general, kind of if there's a deteriorating or degrading human rights situation. If this is contributing to that, or if the negotiations will even come to a lower minimum standard.
I mean, I think from a UK perspective, where it's deteriorating very fast, the EU, there appears to be at least a balance between some states who are arguing that we maintain certain standards, but there's clearly that whole block around Hungary and Poland who are trying to bring those standards down. And I think also then the countries of first arrival have got very practical problems. I mean, it's a kind of three-way split between countries that would really like to destroy a lot of the safeguards in a rather Trumpian way, countries who really need solidarity, and then countries who don't need the solidarity, but intellectually can see that they need to maintain standards. So in some ways it's kind of positive in that 2/3 of the countries appear to be trying to maintain standards. Whereas in the UK, it's difficult to tell who is trying to maintain standards on a political level.
In just to add to that, I mean, there's a natural temptation to think that it's quicker and more efficient to stop people at the borders and turn them back if they don't have a basis to be in the EU. But we feel that's as utopian a vision, you know, that could happen at the border. In that, you know, especially for children, as our bottom line, our basic line is, you know, to assess the situation of children, the border is not the setting to do this. It's typically restricted, it's cramped, there can be lack of access of actors to it. And best interest assessments take time, no matter whether a child is unaccompanied or within a family. So if we get to the point where we say you need to be away from the border to do this, then I mean, on the positive side, you can say that a border procedure nonetheless can serve as a tool for more effective case management. But then it really needs to be resourced to do that. And then it can meet all the requirements of channeling people into processes that will end up with proper durable solutions, including return, more efficiently and more effectively. So I think people need to be very practical about this, and that's why it's so interesting to hear the border countries saying, look, you know, let's be very careful about what we think can be achieved at the border. They have the experience. The hotspots were intended to be something that precisely allowed effective triage, and it went exactly in the opposite direction, at least in Greece. You're muted, Jyoti. Thank you.
Sorry. We had one final question also about relocation and accountability and follow-up after relocation, and monitoring the situation of a child or outcomes of the child after relocation. And there I could briefly reply just to say one of the links I posted to a webinar above had some of the NGOs involved in reception and care for children in the relocation countries, like Germany, sharing their experience. And I think there's a recognition that it would be good for them to have more opportunities to share the processes and the tools they have for accompanying children in this process. But I think it's also a point for our future advocacy to look at your question more closely, Melina, about how are we really, I think also in the future mechanisms under the pact, if a child is relocated, for example, the EU member states have very different national protection statuses, you know, also different procedures, whether they have a way to determine statelessness or grant a permit, or so I think the outcomes after a child is relocated, it can mean many different outcomes as far as the protection status they're granted, whether they have opportunities for family reunification, whether they have a pathway actually for vocational training or citizenship within a short time. So I think the question of monitoring under the solidarity principle and looking at relocation and outcomes, there will be a lot to discuss and to follow, and it's a good question for a future webinar and future advocacy work. I don't know if others want to react, and then maybe we should wrap up.
I think in fact we should we should hand back to Vesna, but first to thank everyone for joining us, and in the hope that it can prove useful to you, and to say the paper follows, and we'd be very much looking forward to hearing from you. And don't forget to visit the website of Children in Migration as well. Over to Vesna.
Thank you very much, Rebecca. Thank you, Jyoti. Thank you, Nadine, for sharing your time expertise with us today. It was really, like always, a pleasure to work with you. As I said in the beginning, there was a few questions about the recording and the PowerPoint presentation. Yes, we will be uploading all the materials to Child Hub platform. If you registered it for this webinar, you will get information on the email when the recording will be on the webinar page. And two final notes from me. I will share evaluation poll on the screen. We would really appreciate your feedback, like always. And also, if you would like to receive a certificate of attending this webinar, you can write an email to email info@childhub.org. I will write it in the chat. And you will receive a certificate on your email in a matter of days. And in the end, thank you all for being with us in today's webinar. Please stay in touch also with the Child Hub webinar page, and please be in touch with the new interesting topics of the webinar that we will have in the next period. And I wish you all a nice rest of the day. Thank you.
Thank you. Bye, everyone.
Bye-bye.
Thanks, Vesna. Bye.